the appeal of Newcastle upon Tyne Hospital NHS Foundation Trust against Abbasi and all, and King's College NHS Foundation Trust against Haastrup and all.
Well, can I just tie up a loose end from yesterday in case the learned friend wants to deal with it? Take 1 minute. You asked me a question about whether end-of-life withdrawal of treatment cases only come to the High Court where there's a dispute. And I mentioned, the Court will appreciate that they come via two routes. If it's a child, it comes to the family division under the inherent jurisdiction. If it's an adult, it comes to the Court of Protection under the Mental Capacity Act 2005. I mentioned a case called NHS Trust versus Y, which we've sent through in 2018 in this court, which looks at the relevant law. Because of the way the case configured, the question that was asked and answered was, is it mandatory for the clinicians to come to the High Court, even if there's consent on the part of the family? And the answer to that question is no, it's not mandatory. But there are observations in the judgment of Lady Black about the possibility of doing that and the desirability of doing that if the clinicians feel it's appropriate, even in a case where there's consent. And my instructions are that in practice it's rare for that to happen, but can happen where there's no family that can properly consent. That's one situation. Or where there is a material dispute between the clinicians on the issue of withdrawal of treatment, where they would want to come to a judge to work out those disagreements and get a ruling from the court. As I say, we've sent the authority through. Thank you.
That's very helpful, thank you. Mr. Quintavalli.
My Lords, this case concerns injunction-making practice in the family division, which we say has become divorced from underlying law and principle. It's not the parent's case that the family division doesn't have jurisdiction to make injunctions, nor that they shouldn't be made in appropriate circumstances. But it is the parent's case that an injunction applied for an end-of-life proceedings, which have been held in open court, in circumstances where the privacy rights have been waived by the parents and the child, that these should be subject to the same principles and approach as those which would apply if a similar injunction had been sought in another court, in other proceedings. There's no reason why there should be different rules or a special jurisdiction for end-of-life proceedings. And if this is correct, this means that this case potentially will have broad application for the making of privacy injunctions throughout the High Court, and there is therefore an evident need for coherency with existing principles and practice in the other divisions of the High Court. The parents agree that the Court of Appeal was correct to discharge the injunctions, and Part 2 of our written case responds to the Trust's criticisms of the Court of Appeal's directions on compelling evidence, risk, generic evidence, and open justice. However, we maintain that the Court of Appeal had a shortcut to the discharge path, since the Court should have found that there was no jurisdiction to make the injunctions in the form and manner in which they were made. We say that the Court of Appeal was wrong to have found that there was jurisdiction for the reasons contained in Part 1 of our case, to which I shall presently turn. Before, though, by way of introduction, I would like to look very briefly at some general features of end-of-life proceedings in the family division, which are relevant when it comes to applying legal principle. The first is that end-of-life proceedings, unlike some other types of children proceedings, are private law proceedings. In the case of children, they typically involve a dispute regarding medical treatment choices between the parents who have parental responsibility and usually want treatment to be continued, and clinicians who don't want to continue providing that treatment. Sometimes the dynamic is reversed, and it is the families who want the treatment withdrawn, and the court will be aware of the Jehovah's Witness blood transfusion cases, for example. But in either case, it is a disagreement between the doctors and the parents' wishes, an exercise of their parental responsibility, which leads to the litigation. There are some cases where both doctors and parents are agreed, but the matter is still brought to court. A notable case is that of Bland, which is discussed in the case of NHS Trust Y. But there, the concern, and that was a Pre-Mental Capacity Act case concerning an adult, but the concern was to ensure that what the family and medics wished to do was lawful. There are other cases where there may be a court intervention despite the doctors and the family being agreed. And one case is the case of which we can send up to the court, is the case of In Re B, a minor wardship medical treatment, a 1981 case which involved a newborn baby girl with Down syndrome who had an intestinal blockage, which if not operated upon would have led to her death within days. And in that case, the treating clinicians and the parents had decided not to operate and to let the child die. But the local authority intervened and made the child a ward of court and litigated the matter up to the Court of Appeal to oblige the operation to go ahead. But that was a case where they had assumed parental responsibilities, having made the child a ward of court. But in any event, the court is called upon to exercise its parens patriae powers and to make declaratory relief in the child's best interest and to resolve the underlying dispute. But these applications for declaratory relief under the inherent jurisdiction are not public law proceedings and do not of their nature involve the state exercising statutory powers. The proceedings can be brought by anyone with a connection to the child. Typically, they're brought by NHS trusts, which of course are emanations of the state, but individual clinicians could bring the proceedings too, so could a private hospital if the child was being treated there. But the consequence of this, and it is an important one, is that there's no statutory duty on the part of the hospital or the clinicians to bring the proceedings. In some of the cases which have recently come before the courts, there have been bona fide offers from highly reputable hospitals, overseas hospitals, to admit and treat the children concerned. And there's no reason why an offer could not have also come from a UK hospital, but if a treating hospital decided to collaborate with the parents and to transfer the child to the other hospital, rather than to initiate legal proceedings, it would not be in breach of any legal duty. When proceedings are initiated by a trust, and this I don't believe is a matter which is in dispute, this is evidently done on the advice of the treating clinicians, who then may be the same who act as witnesses in the proceedings. The trust as a legal entity would not properly act unless its own clinicians had advised it to do so and confirmed that there was a strong legal case for the clinicians not wanting to continue treatment. It's a big request to interfere with parental responsibility in this area. And the fact that almost all cases are determined in the favour of the trust in these circumstances indicates that decisions to proceed with litigation are taken on a considered basis. But the significance of these points relates to the notion that we see in various judgments or articulated in various forms that clinicians are somehow inadvertently caught up in the proceedings over which they have no control. And we say this is simply not the case. They're usually only proceedings because a decision has been made by the clinicians which conflicts with the holders of parental responsibility. And the proceedings would not have been brought if the clinicians had managed to reach an agreement with the parents. The second feature of end-of-life proceedings, which I would like to highlight, is the extreme haste with which they typically move, and that may also explain the approach to injunctions that that we see. It may be that the decision to go to court is a last resort, embarked upon when all other avenues to resolve disagreement with the parents have failed. And so by that stage, matters become particularly pressing. But be that as it may, there's very little time for anyone involved even to catch their breath once these proceedings are initiated. And the significance of this fact is that the question of whether or not clinicians should be anonymised, it may not be one that the parents who are caught up in the proceedings, perhaps struggling to arrange legal representation at very short notice, are likely to be concerned to challenge or have the time to do anything about it at the time. There are more pressing concerns to deal with. Also, it's very unlikely that there'll be time for the court properly to consider questions of anonymity, to set dates for return hearings, and things just have to move. And so, as a result, the RROs are made almost by default, with little, we say, consideration of issues of principle or proportionality, and certainly few, if any, reasons why the orders are made are ever given. The Midran Amit case, which we looked at, the court was taken to yesterday, it is a notable exception. There was a short judgment explaining why the anonymity for 360 clinicians was believed to be necessary. But that, in that case, that order was made because there was a challenge by the parents in the course of the proceedings. It's an unusual judgment, in as much as orders made usually in the family division in these cases don't give reasons. The third feature, which I'm going to deal with very, very briefly, but we'll return to later, is the nature of the evidence provided by treating clinicians in these proceedings. And it's usually given in the form of what might be called quasi-expert evidence. My learned friend talked yesterday about the treating clinicians being witnesses of fact. But when we come later to look at the Isaiah Haastrup case, we shall see that the evidence that the witnesses are giving is clearly opinion evidence. It is just that they've not been formally instructed as expert witnesses, and this does have relevance to the open justice principle. The fourth and final matter, aspect of end-of-life proceedings, which I mentioned at the outset, is the extreme importance of the subject matter. Such cases are one which, it can be said without any risk of exaggeration, involve the most monumental decisions the courts in this country are called upon to decide. In cases which underlie this appeal, the courts are being asked literally to determine whether a child would live or die. Now, clearly, this makes the decisions matters of great sensitivity, but they do raise, as a result, great public interest because they touch upon questions of the profoundest importance. And it would be, we say, a rather anomalous result if the more controversial the decision, the greater the need for curtailment of the open justice principle. We say instead that the fact that they are matters of great concern and do arouse passions makes them, and because they do deal with questions of the profoundest importance, makes these cases ones where the open justice imperative is the most engaged. It is understandable that the hospital trusts involved were concerned about being caught up in a media or social media storm. But subject only to the family's rights to privacy, we say that there's the most pressing need for open justice in these cases. And that it's difficult to imagine any case, whether in the criminal or civil courts, where the workings of the state need to be subject to to greater scrutiny. So I would now like to look at the question of jurisdiction and I will, at a later stage, I was proposing to do it at the outset, but I would like to take the court to certain aspects of the injunctions, and I think it's more appropriate to do it when they arise. But turning to the question of the High Court's jurisdiction, it's true that the limits of the High Court's power is often elusive, since theoretically, as we've seen, the powers of a judge are without limit under Section 37 of the Senior Courts Act. But limits to this power have been recognised by the courts and imposed by statute. And we say that, and we've identified 6 reasons, which have been grouped into 4 grounds, why the courts did not have jurisdiction in the strict sense to make the orders which they did. And we say these reasons are based on firmly established principle, logic, and statute. If we're wrong about this, and that the arguments that we adduce in Part 1 relating to strict jurisdiction or constitutive jurisdiction don't apply, then nonetheless they carry substantial weight when it comes to the question of the proper exercise of discretion in Part 2. So I make no apologies for going through these points now, because they either apply to the constitutive or the adjudicative jurisdiction. The first ground relates to the inherent jurisdiction and to its limits. And both the President and the Court of Appeal were agreed that the injunctions were made under the Court's inherent jurisdiction. The key passages in the judgments, perhaps if your lordships could note them, I don't propose to turn to them, but are in paragraph 74 of the President's judgment, which is on page 339, and then in paragraphs 45, 46, and 48 of the Court of Appeal judgment on page 293. The problem, and getting very directly to the point, the problem with the analysis and with the conclusions of both the President and the Court of Appeal is contained in the case of Puja and Tyne's newspaper. And the passage I'd like to turn to in that case is paragraph 18 on page 2512. And there, Lord Sumption says, the inherent power of the court at common law to sit in private or anonymised material deployed in open court has never extended to imposing reporting restrictions on what happens in open court. Any power to do that must be found in legislation. And then he continues, there is a substantial number of statutory restrictions on reporting of court proceedings, with very limited exceptions. All of them are concerned either, one, to protect the administration of justice itself by preventing the reporting of matters likely to prejudice the fairness of proceedings, or to deter parties, witnesses, or victims of crime from participating in them, or two, protecting children and young persons or other particularly vulnerable groups. Then over the page at D, after citing a host of statutory provisions providing for restrictions to open justice, Lord Sumption concludes, the dependence of this area of law on statute and the extent of statutory intervention mean that it is fair to speak of a statutory scheme occupying the ground to the exclusion of discretions arising from the common law or the court's inherent powers. Lord Tyne made this point with the concurrence of the rest of the appellate committee in Ries, paragraph 20, and then the passage which, well-known passage we looked at yesterday. And it may be that this passage provides an answer to my Lord Sales's question yesterday regarding what Lord Tyne meant by jurisdiction. It would seem that Lord Tyne was speaking of a lack of constitutive jurisdiction under the common law. So that his words, "it needs to be said clearly and unambiguously that the court has no power," should be given their straightforward meaning.
Now, if I can interrupt you for a moment, clearly what you've taken us to is very important, and it's pretty clear in what is said about restrictions on the reporting of Lord Sumption, the way he puts it is restrictions on what happens in open court. Now, in this case, a lot of the material, as I understand it, isn't concerned with what happened in court, but what happened in hospitals. So I presume you're going to take us on to how you deal with
I will.
that material.
There are essentially two aspects.
Particularly in the Abbasi case, there's really very little material that was deployed in court, as I understand it. Rather more in the Haastrup case.
Yes, the Abbasi case would have been in open court,
yeah.
and but it didn't get to that stage.
Yeah.
And this is one of the aspects which slightly complicates the analysis of this case, because there are different targets. One of the concerns in the Haastrup case has been the anonymization of the medical witnesses during the course of the proceedings itself. And so in that case, we say that the open justice engagement is very, very clear. And then, of course, there are other issues relating to injunctions being made to parties who have a tangential or perhaps don't have any direct connection with the proceedings. But the objections to the use of injunctions to protect those parties is a different objection to that which concerns the restriction on the naming of witnesses, and I will deal with that.
The other point you may need to deal with is that Lord Sumption and Lord Tyne also were speaking about the extent to which the common law could be used, and clearly they're taking a very restrictive view of that. But in the present case, the argument against you is based on statute, on the Human Rights Act.
Yes, and that there is a power under Section 6 of the Human Rights Act in conjunction with Section 37. It is a position which I certainly agreed with from the outset of these proceedings when they were before the President. It seemed that the basis of the jurisdiction wasn't in dispute at that point. So that's not an argument I take issue with. That jurisdiction exists. It is just how it's exercised is what's important, and we say that it wasn't exercised in these cases in a manner which is compliant with the Convention or within Res itself. But where the inherent jurisdiction, perhaps if we look at it in Res now at page 3155, because there's another important paragraph which deals with the interrelation between the inherent jurisdiction and the Convention. And again, it was one we looked at yesterday, but it's one we say that is open to a different interpretation to the one which was proposed. And if I could just have a look at this passage, it says, "At all stages in this litigation, the provisions of the ECHR have been carefully taken into account, but at first instance and in the Court of Appeal, much of the debate centred on the inherent jurisdiction of the High Court to restrain publicity. Mr. Justice Headley in the Court of Appeal were asked to exercise this inherent jurisdiction. Lady Justice Hale, with the agreement of the other members of the court, observed, now that the Human Rights Act 1998 has enforced, the relevance of the jurisdiction may simply be to provide the vehicle which enables the court to conduct the necessary balancing exercise between the competing rights of the child under Article 8 and the media under Article 10. And this was the argument both counsel had adopted. But Lord Steyn then says, after citing various authorities which had been relied upon, the question arises whether such an exercise in a case such as the present is still necessary or useful. The House unanimously takes the view that since the 1998 Act came into force in October 2000, the earlier case law about the existence and scope of the inherent jurisdiction need not be considered in this case or in similar cases. The foundation, and this is the important point we say, the foundation of the jurisdiction to restrain publicity in a case such as the present is now derived from convention rights under the ECHR. This is the simple and direct way to approach such cases. In this case, the jurisdiction is not in doubt. And then the inherent jurisdiction is not wholly irrelevant. It may have some interest in regard to the ultimate balancing exercise. But what we say is that this whole issue about whether or not there's a vehicle or not is not one which is not an approach which should be adopted anymore. You simply start from the convention. And talking about vehicles is neither necessary nor useful in cases where the convention applies. And what we say is that the way these cases, the way that the court's obligations, positive obligations under Article 8 arise is through Section 7 of the Human Rights Act, which is using the language of vehicles, which is the vehicle for making, for engaging the court's jurisdiction.
But why doesn't it arise under Section 6? I mean, Section 6 that actually imposes the duty on the court. Section 7 governs how a remedy might be sought.
So what the answer to that, and I'll be looking at that, and I'd rather not do that immediately, if I could just defer for a moment, is we say that in short, that the duty under Section 6 only arises if the court has a duty to act. It's not a duty which just happens, which the court's obliged to act upon simply because the matter's been brought before it. So there's a duty not to act incompatibly with the convention, but that duty is only triggered if there's a prior duty to under Section 6 at all, and we say Section 7, which then triggers that duty in these sort of cases.
I'm conscious that this point about Section 7 is something that's never been raised in these proceedings until I mentioned it yesterday, and we are where we are with these proceedings, but it may be that if the appropriate procedure is for the application not to be made by the trust but by a representative doctor or nurse, then that's useful guidance that this court could give. But as I say, I'm conscious that this isn't a point that's ever been raised in these proceedings until now.
Well, my lord, it was raised directly as part of our second ground of appeal in the Court of Appeal. It just didn't find its way into the grounds before this court. Right. But it was certainly raised, and it was raised in relation to the Ellen Kane point. If I could take the court to page 2997.
Well, sorry, just if you're moving away from Section 6, can I just check? One might think that there could be some situations where a matter was so clearly brought to the attention of the court, whether by proceedings or not, that the court should or does recognise that convention rights are involved in such a way that the court needs to take measures to protect them, to act compatibly. You seem to be saying that Section 6 wouldn't impose a duty on the court to take such action at that time. And I question that.
One of the central issues in this case is the Section 8 duty, or rather positive obligations under Article 8, Section 6 duty, how the court may give force to them. But the positive obligations under Article 8 are obligations which fall on the shoulders of the state. And it may be that in certain circumstances the court has to discharge those obligations because the state hasn't, and we'll be looking at the case of von Hanover and X and Y in the Netherlands, which concerns situations where the domestic law didn't make adequate provision for the protection of privacy rights. But in normal circumstances, that duty doesn't fall on the shoulders of the court. And especially in situations...
sorry to interrupt, but I just thought that will depend a lot on the particular context. Sometimes the court may be the natural actor within the domestic legal order, if you like, on behalf of the state. I mean, obviously, when you're moving from Article 8 in the ECHR itself down to the Human Rights Act, you've moved from the international sphere, where the state is the person who acts, down to a realm in which individual public authorities have to act. But sometimes I would have thought that the court could be the most natural public authority with the obligation to act compatibly with the Convention rights.
Yes, and cases which we were taken to and which we've cited ourselves in our written case include the Venables case, for example, or all those cases relating to contramundum orders to protect.
Venables is an example of a case being brought before the court, an application being made to the court by a person who had victim status. But one can envisage situations where the court, as an arm of the state, would itself have an obligation to respect convention rights in the absence of an application. For example, if a judge, for example, were to treat counsel less favourably because counsel was of a particular ethnicity or a particular gender, that would be a contravention of convention rights. If there was a witness being, say, for example, a rape complainer being cross-examined in a very aggressive and humiliating manner, and the judge failed to intervene to protect the witness, then that might well be a contravention of the witness's convention rights. There may be situations where it's part of the proper role of the court to act in a way which protects convention rights.
Yes, and it's our case that proper role would arise if these applications had been made in a normal fashion, that is, by the people who were seeking the protection, and that they were evidenced applications showing why they needed the protection of the court. So it's not...
I remember when, not long after the Human Rights Act came into force, there was a great deal of discussion of what the impact of Section 6 was, particularly in relation to so-called horizontal effect. I had a quick look this morning to see if I could find any authority on where the issue had been discussed, and I didn't find any after 5 minutes looking. But it may be that more careful research might come up with something.
I mean, it occurs to me that the timing factor which you yourself emphasised, everything moving very fast, might be relevant to that. I mean, things may be moving very quickly, and it may appear to the court, even though no application has yet been made, that convention rights may, and I use the word advisedly, one can't be sure, may be being prejudiced. I mean, I just wonder whether there might not be some obligation on the court even to sort of pause things to at least allow, if it's a case which requires a proper application to be made, to allow that to happen, to ensure that things, the convention rights haven't been lost or infringed unnecessarily just because no one had thought about or had the time to prepare a full application.
The parents' case in the Court of Appeal, and this is recorded in the court's judgment, was that there was no objection taken to the injunction, the initial two injunctions in the Abbasi case. For that reason, they were, to all intents and purposes, interim injunctions, holding the ring. And they were giving an opportunity for people who might have privacy concerns to come forward and to articulate those concerns. So one would have expected, if the case had proceeded to court, to a final hearing, that a witness who was still protected at that point by the injunction would have had an opportunity to explain to the court, firstly, whether they wanted the injunction. We'll see that many pediatric practitioners don't want these injunctions. And secondly, what the reasons are why they think that injunction is necessary. And these are the sort of principles which apply, certainly when anonymity orders are sought in the King's Bench division, for example. It's simply not the case that they're made and then left in permanent form without any sort of evidence being adduced as to why they're necessary. And one of the, as we'll see, the Lord Sumption says that the touchstone of this jurisdiction is necessity to abridge the open justice principle. And at some point, a judge who's making the decision has to address that. Is it necessary that this witness is anonymized? The witness may say, look, I'm not prepared to give evidence unless I am anonymized. Now, that isn't the case, and that's never been stated by any of the witnesses. And in these cases, that hasn't been relied upon by a ground. But if a witness did say that, then the judge would have to decide whether that was reasonable, whether it's impossible to give effect to the child's rights if the witness isn't going to testify. Or perhaps the judge will say, well, it really doesn't matter. This is only a witness of fact. What matters are the expert witnesses. And they're not typically, the formal expert witnesses, they're not typically anonymized in these cases. In order to determine what the child's best interest is, we can dispense with that witness, so we're not going to call them.
But I mean, it's not, forgive me, it's not just going to be a question of whether the person's willing to give evidence. You know, I could imagine a situation where a conscientious doctor, you know, almost thinks, this is an important matter, as you've emphasised. I'm just morally bound to give my evidence and will come forward and give evidence almost whatever the situation. But nonetheless, they ought not themselves to be subject to harassment after doing that. So they're willing to do it, that, you know, with some reluctance, recognising they'll be harassed, they're still prepared to do it. But still, their Article 8 rights would be infringed if they are harassed. So would there not be scope for a court, if that were the situation, to, on proper application if one's required, to make an order protecting them against that harassment, which would be an infringement of their own Article 8 rights?
Yes, and if it's an application relating to a witness in the proceedings, then the judge deciding whether to make such an order is going to have to establish, first of all, that the clinician does want it. And if an application's been made, it's clear that they do want it. But then it's going to have to look at the threshold requirements that Article 8 has. And then it's also going to have to balance the open justice imperative. And when we look at in res, because one notable aspect of in res is whilst the open justice imperative featured strongly in that case, Lord Steyn made it clear that this was not a case about Article 6 rights, because the mother in that case had waived those rights. She'd said, I'm quite happy for myself not to be named. So that's why Lord Steyn says this is not a case where Article 6 is involved. But in cases where the parents haven't said, we're happy for witnesses to be anonymized, or for us to be anonymized, or for the parties to be anonymized, because in family proceedings, the default position, of course, is that there will be anonymity for the parties. But where that anonymity has been waived, then the Article 6 rights involved also have to be balanced. And that's not a balance that either the President or the Court of Appeal considered, maybe because in res it didn't feature, but it didn't feature for a very specific reason, that the mother had waived those Article 6 rights. So that's something else which the judge is going to have to decide when deciding whether to make an order to protect the witness from possible harassment. But certainly the power exists, and it may well be that the parents don't oppose it, and the press doesn't oppose it, and it isn't a problem. But the application has to be made, and it does have to jump through the hoops, as it were. I wanted to conclude on the article, on the Section 6 and Section 7 points, just by looking at passage from the case of Ellen Kane, and it's at 2997. And it's paragraph 99, right at the bottom of the page, where Lord reads judgment. And he says, Lord Hope stated as a general proposition in relation to the court's role under the Human Rights Act, it is not for us to search for a solution to the appellant's problem, which is not to be found in the Strasbourg case law. And then, going over the page, he says, Lord Bingham stated unequivocally, a party unable to mount a successful claim in Strasbourg can never mount a successful claim under Section 6 and 7 of the 1998 Act. In the same case, Lord Nichols stated at paragraph 34 that the Act was not intended to provide a domestic remedy where a remedy would not have been available in Strasbourg. So certainly a clinician who was denied anonymity protection would have a claim in Strasbourg. But a trust who doesn't have any Article 8 rights would not. And it may seem a technical point, but it isn't, because the fact that these injunctions have been applied for by the trust without providing any evidence as to who requires the injunctions and why they require them is precisely the problem. It's impossible to conduct an in res balancing exercise, and that is what is required. I
rather had the impression that the trust was applying, really representing the clinicians in its employment. So, this might be objectionable, I don't know, but it's not so much relying on its own Article 8 rights as saying, we're a responsible employer, we have these clinicians in our employ, their Article 8 rights are going to be infringed. please, court, look at their rights.
So, my Lord, perhaps that would be I'll skip over the next steps of my presentation, which are contained in my written case, and they deal with the powers in the inherent jurisdiction which is still applicable where someone doesn't have convention rights. The court, those powers haven't been done away with, but which deal with the exceptions to open justice in cases involving intrafamilium disputes.
But you drew attention to what would happen in Strasbourg.
Yes.
I mean, again, I would have thought that if you had a case where the trust had brought or had made an application essentially on a representative basis to protect the Article 8 rights of individual employees, I'd be surprised if and that failed, let's say, and those individuals then wanted to take their application to Strasbourg. I'd be surprised if Strasbourg would say, well, you can't because you didn't exhaust domestic remedies. Wouldn't Strasbourg look at it and say, well, the trust brought a claim on their behalf, in effect, so there was an attempt on their behalf to invoke the domestic remedies, and then Strasbourg would look at that case and examine it for itself.
Well, there are two problems there. The first is that we haven't been shown any authority where that has ever happened, and one would have expected that it might have, where there was an individual applicant who was able to bring a case to Strasbourg when in the domestic proceedings they hadn't brought a case directly themselves, but a corporate body had on their...
So are you saying that, in fact, the individual could not bring a claim in Strasbourg because they would not individually have exhausted domestic remedies?
And for the second reason, and when we look at Article 8, it's going to become apparent. Strasbourg relies on the domestic courts applying and analysing the application of the convention rights, where someone hasn't, and conducting the balance as well, but where someone hasn't provided those elements, the domestic courts can't do it on their behalf, so that Strasbourg court's not in a position to know what balance had been conducted and whether it was in conformity with Article 8 or not.
Yes, thank you.
But this, I'll leave aside and refer your lordships to the written case on the inherent jurisdiction, because those powers do exist, and they do exist where, in a circumstance like the present, where someone doesn't have convention rights, and so that the statutory scheme hasn't in fact replaced, doesn't occupy the territory of the inherent jurisdiction. The inherent jurisdiction would still apply, and a trust would be able to ask for the court under the inherent jurisdiction to apply, to look at applying, subject to the necessity requirement, whether the intrafamilium exception applies, that is, that anonymity is granted to purely private disputes. This takes us back to Scott and Scott, where these exceptions were first explored, but it's been consistently reaffirmed since. Or secondly, whether it was a case where the imperatives of justice required that anonymity was conferred. And just very, very briefly, the point we say on the intrafamilium point is that, and this is clear from Scott and Scott as well, is that where the parties don't want anonymity, then it's waived, and it's the court's only applying privacy because the parties want it. Where the parties don't want it, then the open justice imperative takes over. And secondly, we say in any case that times have moved on, and that the open justice imperative does bite, because this is very important matters that are under discussion, and the courts have been called upon to resolve. And whereas that doesn't mean that the parties have to be named, it certainly means that the witnesses have to. And I mean, this is another aspect of these proceedings. Essentially, and if we look at all the statutory provisions, it becomes clear that they're all focused, as Lord Sumption identified, in protecting the interests of the child in these cases. And in order to protect the interests of the child and the privacy of the child, it's necessary. Maybe the child doesn't want to be named, the parents don't want the child named, they don't want to have any media attention. It may be necessary that the hospital is anonymised. It may be necessary that treating clinicians are anonymised because of the risk of jigsaw identification. But that's all done in the interests of the child. And that's why perhaps it's been routine for these sort of orders to be made, and judges haven't had to think about making them. But we then get in a situation where the parents and the child, the parents acting on behalf of the child, don't want anonymity, or the name's already out in the open, as is the name of the treating hospital, and that was the case in the Isaiah Haastrup case. And then anonymity is still made for the clinicians. But it might, we say, be reflexively made, because it's always been made. But the reality is it shouldn't be made if it's purely being made under this inherent jurisdiction, because the inherent jurisdiction doesn't exist to protect the anonymity of witnesses, but only the child in these cases. And so therefore that's why it isn't the inherent jurisdiction which is applicable, but we go back to it's the Human Rights Act which then becomes applicable. On the interest of justice, all I say is Cuja, paragraph 14, page 2509, necessity remains the touchstone of this, 2510 at E&G, necessity remains the touchstone of this jurisdiction. And that is important because it is a high threshold. Ground 2 combines three different reasons why we say third-party privacy injunctions are not legitimate. That is, an injunction applied for, in this case, by a trust on behalf of other people. And the first case I'd like to take your lordships to is the Broadmoor Hospital Authority case, which starts at page 2103. And this case is very helpful on the facts for us, because it concerns a hospital who was trying to obtain a privacy injunction. It's a case which was looking at broad principle of when injunctions, what sort of statutory authority is needed to obtain injunctions, but by public body. But it so happens that we've got a hospital and we've got a privacy injunction which was sought to be obtained to protect third-party interests. The case concerned a patient at the hospital who had killed an occupational therapist and had then written a book which he had arranged independently to publish. And the book explained the motives for the killing, which were essentially to obtain publicity and to get press coverage. And it revealed intimate and embarrassing details about other patients. The hospital was worried about distress to the family of the victim and also the reaction of other patients for whom they had responsibilities and a duty of care, as well as concern about the welfare of the author himself, who could be attacked as a result of the publication of the book. And as explained in the judgment, the case ended up concentrated on the question of the hospital's statutory responsibilities for the author and whether it was able to obtain an injunction to prevent the publication of the book. And the Court of Appeal was in agreement on some points and not on agreement on other points. But where they were agreed was, firstly, that this injunction shouldn't be made as a matter of adjudicative jurisdiction or of the court's discretion. But where they were agreed was that there was no power on the court. There was no power. The trust was not able to obtain an injunction as a matter of strict jurisdiction to protect the privacy interests of third parties. And I could take the court to various passages of the judgment to show this. The first is at page 2123, paragraph 56. Paragraph 55, rather. And this is the test which Lord Justice Waller endorses, that Lord Wolford set out, and it's the test for establishing the existence of a jurisdiction in a strict sense. And it's this: for public bodies given a statutory responsibility, which it is required to perform in the public interest, then, in the absence of an implication to the contrary in the statute, it has standing to apply to the court for an injunction to prevent interference with its performance of its public responsibilities. And the court should grant such an application when it appears to the court to be just and convenient to do so. And then Lord Justice Waller agreed with Lord Justice Morritt that on the facts there was no interference with the exercise of the statutory responsibilities by the publication of the book. And the test, which is set out by at page 2123 at F, at paragraph 57, in the middle of that paragraph, the test for whether a conduct can be said to be designed to frustrate the discharge of the hospital's duty is basically whether the conduct can be said, whether his conduct cannot be said to have been designed to frustrate his treatment or the treatment of others. So the question is, was this book being written in order to frustrate the treatment of the other people? And the answer there was no. That's not why he wrote the book. He didn't write the book to frustrate the hospital's treatment. He wrote the book to obtain publicity. So,
and would the hospitals in this case have a statutory responsibility to perform in relation to the health and safety of other patients in this hospital, and particularly in the paediatric intensive care units?
It may well do, and this is one of the routes that may be open to a trust to obtaining an appropriate injunction. But that's also going to have to be evidenced. They're going to have to explain what their statutory responsibility is and how a patient, the family of a patient, naming the doctors that treated their child, how that will be designed to interfere with the discharge of that duty. And that hasn't been done. I'd like to... Lord Wolf had the broadest approach to the less restrictive approach on jurisdiction. But I'd like to take the court to paragraphs 31 and 32 on page 2117.
Can I just check? It seems to me Broadmoor is prior to the coming into effect of the Human Rights Act, isn't it? So I just slightly question how helpful it's going to be for us, where you accept that there is jurisdiction if the Human Rights Act says that the court may or should act.
Well, there is jurisdiction under the Human Rights Act, we say, but not to act on application of the hospital itself.
Right.
And that's the proposition. And that's that's on those paragraphs 30 and 31 of Lord Wolfe. It's where he says, there are submissions of Mr. which I would accept. First, I would accept that the authority cannot bring proceedings to protect any patient's right to privacy or confidence. To protect other patients, the authority have to rely on the interference which the conduct of which complaint is made would have on the authority or on the performance of their duties.
Mr. Pinfield, I think you told us, and I've no reason to doubt it, that the occasions on which these RROs are originally granted, usually in great haste, don't lead to much reasoning about the basis upon which they're granted in terms of reserved judgments or even extempore judgments. I think there's one notable
There's usually no reasoning at all.
Absolutely. But can it not be said that at that stage, where the hospital, the trust, is going to court, if you like, for help and guidance in the performance of its public health function in relation to a particular child, who will be one of presumably a number of children in that care unit, it really is, insofar as it's getting an RRO, seeking to protect from interference the performance, the better performance of that function. In the sense, it's got to go to court, so it's got to, as it were, externalise what's happening in order to get the appropriate protection or to resolve the relevant dispute. But it's trying to deal with the risk that the very act of going to court will make it more difficult for the hospital to perform its health function in relation to the child or children in that unit.
Certainly, if the evidence exists that the welfare of the child is going to be compromised by publicity, which is going to compromise the treatment that the child's going to be given, that would be a legitimate ground for the court to make appropriate injunctions during the course of the proceedings themselves. But there's that statute already provides for that, for that protection. And for that very reason, we've where I don't agree with the premise of the question is that, firstly, that in a strict sense, that the trust has to go to court. I tried to lay out at the outset that this is and firstly, and secondly, it may be highly desirable that it does.
Well, it has to, or concludes on advice that it should.
The difficulties that
in a way, it's a matter of respect for the parents. I mean, if there's a genuine dispute between the doctors and the parents as to what is in the best interests of the child, then going to court to have it resolved is surely preferable to either party acting in a way that disregards the views of the other party.
Well, the difficulty there is, in certain circumstances, that will certainly be the case, particularly in cases where parents don't have any alternative options. We have a group of treating clinicians who are looking after the child, who are not prepared for their own reasons of professional conscience to carry on treating, and that right has to be respected by the courts. And in those circumstances, it's certainly appropriate that the dispute is brought before the court. But in other cases, there are alternative treatment offers available, and it is open to by reputable hospitals offering to treat the child, who obviously consider that it's an acceptable therapeutic option to carry on treating. In those circumstances, there's no need for a hospital to assume a sort of public law persona, which they don't have under these proceedings. They're private law proceedings, and practically speaking, most of these cases, which originate in paediatric and intensive care units, will inevitably be within the NHS. But in principle, there's no reason why they should be. They could be in a private hospital. There's no public law duty that's being discharged by bringing these cases. And that is the point I was trying to make.
I mean, a legal issue is the best interest of the child. And I haven't been involved myself in the well-known cases, so I speak on the basis of what I know from reading newspapers. But isn't the issue in those cases also whether the proposal to move a child from the place where the child is, perhaps to a clinic in another country, would be in the best interest of the child?
The obligation on the court which is on the court, to put, or the paramountcy principle in Section 1.1 of the Children's Act is an obligation which arises when there are proceedings. But obviously, if there are no proceedings, that obligation doesn't exist. And an alternative source of that obligation might be sought, and people have tried to suggest that that public bodies are bound by this, but it may be through international treaty law. But the problem there is that none of that is incorporated. It doesn't impose any justiciable duties on the court. And there have been some cases recently where that's been very much a live issue. There may be an obligation under international law to promote the best interests of the child in all sorts of contexts. But the reality is that this only arises once the issue is before the court. So we're a step before that, and the hospital doesn't have that obligation. It may be good. They may be beyond criticism for bringing them, in most cases, for bringing the matter before court, and they may need to. But that's not a given, and they certainly don't have any duty, is what we say.
I understand that you accept that there is jurisdiction under Section 6 of the Human Rights Act and Section 37, subsection 1, but not on the application of the hospital.
Yes.
And does that mean that if joined in the proceedings the proceedings were brought by the hospital, and also at the same time the second applicant was X, representing all the other clinicians and staff at the hospital, does that overcome the problems about jurisdiction?
Again, I don't want to be giving evidence as to the background of what happened in the Riem case, but we can see from the judgment itself that there was a list of 360 or 370 names, and they were provided by one clinician. But the concern would be, how did that list come to be compiled?
I'm not concerned about whether it's done correctly. I'm concerned about whether that, if it is done correctly, would satisfy the concerns you raise about jurisdiction.
I think it would. But what would be important to know is that people have freely put their names on this list. Junior doctors and nurses in a hospital may not want these sorts of injunctions to apply to them, but feel pressurized into accepting them because the trust has said, right, we're going to apply for an injunction on behalf of all of you.
Just on a purely practical basis, it seems to me that if you remove the hospital as being the prime mover, and you get everyone to sign up to a position that they want to be represented in proceedings, the atmosphere in the hospital in relation to the continuing treatment of the child is going to be adversely affected. You're going to have even more two camps, two divisions, and so it may be that is what you have to have. I'm not saying you don't, but I just raise concerns about the actual impact on day-to-day treatment in a hospital.
I think that we have a divergence between two important consequences. I mean, certainly the parents in these cases are not going to want one would imagine, treatment of their child to be compromised. And in fact, in this case, in the Abbasi case, didn't proceed to a hearing, but the Haastrup case did. In that case, there was no objection made at the time to the anonymity orders during the course of the proceedings. That isn't in dispute in this case. The problem is what happens afterwards. Should they have lapsed at the death of the child when there wasn't any more issue about whether that child's treatment was going to be prejudiced or not? And we say that would have been the appropriate point in time. And that's returning back to the court's inherent powers. The court has powers to control its own proceedings and to ensure that the interests of justice are promoted during the proceedings. But that is not a power which extends, we say, beyond the proceedings, and it's not a power which enables them, as we've seen, to make contra mundum injunctions. So it would be perfectly proper for the court to say, we've looked at the risks. There is a real risk that clinicians are going to be targeted and that it's going to affect the treatment of the child, which is under consideration by the court and which we have to make our paramount concern under the Children's Act. Therefore, we're going to impose anonymity during the course of these proceedings on the evidence which is given. But it's a very different matter to saying, therefore, we're going to prohibit for all time parents from being able to tell anyone about who treated them.
Well, there is an undistributed middle, isn't there? I mean, the proceedings end of necessity if the child dies either because of an order made by the court or before the hearing, as in one of these cases. You say, well, that's the end of that stage of the process, and it doesn't justify a permanent injunction. But would it justify some form of cooling off period injunction in the sense that the care unit's probably got other children in it, the same professionals will be there, and a firestorm in the press or in social media will affect, or is feared to be likely to affect, the performance of their duties if it's about something that's literally just happened?
If the evidence existed, then...
Yeah, I can see that it might need to be supported by evidence, but in principle, if you're minded to think that an injunction may be appropriate, indeed I don't think it's ever been really an issue in this case during the currency of the proceedings, then in principle that might extend to some sort of cooling off period, might it?
It may, and certainly with respect to people who are unconnected with the proceedings, there would be a stronger case for that. I would have concerns with regard to the name of the witnesses during the course of the proceedings, because that really does come smack against the open justice principle. Now, where the parents don't mind, it simply isn't a problem. If they're happy for the evidence which is going to determine the issue before them to be given anonymously, then it's not an issue, and it wasn't directly an issue here. But at a certain point, if the parent says, I want to be able now to discuss doctors who, the evidence they gave, I don't believe it was accurate evidence. I believe that they were being dishonest to the court. I have this proof. They need to be allowed. At that point, their Article 6 rights kick in. They're allowed to insist on the open justice principles applying. And the open justice principle means, and we'll look at the case of Ken Todner, and also look at what Article 6 itself has to say. But that means that witnesses are not subject to protection unless the interest of justice requires it. And that's a high threshold.
I mean, sorry to pick you up on Article 6. It's the second time you've mentioned it. Do the parents have rights under Article 6, which are relevant rights?
They do.
Right. If you're going to come on to it, we'll leave it till then.
I mean, in short, Article 6 applies when a court is determining your civil rights or obligations. And so here, what's being determined is the extent of parental responsibility. So the matter's firmly within the ambit of Article 6. And Article 6 contains...
But is that right? I thought that what's being determined is whether it's in the best, to go back to my Lord's question to you, is whether it's in the best interest of the child to have treatment continued or terminated.
Oh.
That's not about parental rights. That's about the individual rights of the child.
So one aspect of these proceedings I didn't highlight, but perhaps I should have, and it is important, is that these are private law proceedings between the parents and whoever's challenging the parents. The child is only added on as a party at a later stage in the proceedings. And the issue really is about the extent of the parental, it's about who decides, who's making this decision. And the decision is then determined on the best interest of the child, that's true. But it goes directly to parental, to the question of the parents' rights, effectively, to determine whether a child's going to be treated in this hospital or that hospital, according to this. The state is stepping in. This is not this is what's a little bit confusing. The child hasn't been made a ward of court. The parents retain parental responsibility. It could be a route. Maybe in the past this is how things might have been done, that the child would be made a ward of court and then the court's making that decision on the child's behalf. But the parents retain their parental responsibility. And in theory, the court makes a declaration that it's in a child's best interest that he does or doesn't receive this particular treatment. And the parent says, well, I'm going to move him to another hospital that says something else. And this has been the source of a lot of the disputes over the past few years. But we say that
But even that way of putting it suggests that the court isn't determining the extent of the parents' rights. The parents' rights continue throughout.
Well, except that they don't, because their right to determine what treatment the child has can't be given effect to.
Well, they don't have an absolute right to determine what treatment the child is given.
Well, this isn't an ordinary litigation between private parties. The child it's an application to the inherent jurisdiction of a court as parens patriae. Well, a court is being asked to reach a decision itself as to what's in the best interests of the child. The child is party to the proceedings, represented by a guardian, and the hospital trust and the parents are also party to the proceedings. And each of those parties can put before the court their view as to what's in the child's best interests and the reasons why they say that, and then the court reaches its decision.
Except that the child isn't one of the original parties to the decision. This is one of the peculiarities.
It's the first. It's in each of the orders we have by Mrs. Justice Leven in one of the proceedings and Mrs. Justice MacDonald in the other, the child is the first respondent.
So if we look at the reporting restriction orders, which were the first orders made in these proceedings, we can... So if we had a look at EF, page 364, if we looked at the Haastrup injunction.
The child is a party to that.
Yes, if I just... So if we then look at, on the following page, paragraph 2, we see the following persons and or organisations were represented before the court: the applicant and the press association. There's no child because the child hasn't yet been added in as a party, hasn't yet had a guardian.
Yes, well, I can see a particular stage when an ex parte injunction is being sought. the child or the guardian may not yet have been served, may not yet have become a party to the proceedings. But, but if we're talking about what the nature of the proceedings is, the child is a party, and if the proceedings go to a hearing, the guardian is entitled to appear and make submissions to the court.
Absolutely, and it's necessary that that is the case, but it's just one aspect of these best interest proceedings is that they start as private law proceedings between parents and the hospital. If it's under the inherent jurisdiction, the court then has to decide whether to. The court will then typically appoint a guardian for the child and join the child as a party to the proceedings.
You say typically, won't it always do that? I mean, if the order couldn't more profoundly affect the interests of the child. I'd have thought it couldn't proceed without the child being made a party.
If the matter does proceed, then it's certainly the child would have to be joined as a party. Absolutely. But the point is that that's not how they originate these proceedings, and we haven't got in the bundle the family procedure rules and practice directions which show that the way they do. But that is an aspect of these cases. So we say, and it may not be a point which finds favour with the court, but that this is determining the extent of the parents' rights, obligations with respect to the child.
Is there any authority that supports that? That the parents' rights under Article 6 are engaged in these proceedings?
My lord, I'll have to.
Right.
I'll have to get back
on that.
I can't think of anything immediately.
Well, I can envisage an argument that if, for example, the court didn't determine the matter within a reasonable time, that might possibly be a breach of the convention rights of all of the parties to the proceedings. But I'm wondering whether restrictions on the open justice principle amount to a breach of a party's convention rights. And that if there is authority on that point, that would be helpful to see.
Yes, my lord. The second point I can take very briefly, the second reason why we say that these third-party applications for privacy injunctions don't apply, relates to an evidential problem. And that's the problem that, but we're saying it's also, it creates a logical impossibility for the court to determine whether Article 8 is even engaged if you don't know whether the person for whom the injunction is being sought in fact wants the injunction. And this is not just an academic point. I would like to take your lordships to a survey which was conducted by one of the interveners, Paediatric Critical Care Society. On page 1730, we see one of the questions. My apologies that it's facing sideways, but it's an important question, and it goes very much to the issue here. And the question's this. Do you think that reporting restrictions should routinely be lifted at the conclusion of proceedings to allow transparency and increase public confidence in how decisions are made, even if that allowed any of the treating healthcare professionals to be named in the press and social media? And this was a survey which was taken amongst the Paediatric Critical Care Society members. I believe several hundred of them took part. And the interveners say in their submissions that the responses to this survey remain as pertinent now as they were in November 2020 when the survey was conducted. But the majority of respondents say that they do object. They think to reporting restrictions being lifted. But the significance, we say, is that a certain proportion of them, 10% of them, say, yes, they should be removed, and 14% of them say, well, we don't particularly mind. Now, in the context of what we're arguing for, which is an individual fact-specific balancing exercise that INRIES calls for, obviously survey evidence cannot assist in determining whether an injunction should be made in any individual case. But what the survey does show is that it cannot be presumed that all clinicians wish for injunctions, and that therefore no harm is done to them by making blanket class injunctions as a matter of course. It is likely that some of them are going to be harmed by the injunctions, and they may even have their own Article 8 rights violated as a result of these injunctions. So the engagement thresholds, and I don't propose to go through this, the law is well known, but Article 8 essentially, in these sort of cases.
Sorry, in practical terms, what does the court do if for instance, it can presume that the overwhelming majority of the clinicians don't want to be named because of the adverse effects of harassment and so on, and it assumes that one or two don't mind, have no objections. But if you name the one or two, then you've also identified all the rest. What do you do? What's the practical solution to that problem?
And the practical approach would be to make an interim injunction which lasts for as long as the proceedings last and enables those who do want anonymity in the meantime to come forward and explain who they are, that they do want anonymity, and that they satisfy the Article 8 thresholds. And the Article 8 threshold is first of all, is whether there's a reasonable expectation of privacy. And secondly, whether there's objective harm and subjective detriment. And the law is not controversial. I won't take the court to the authorities that are set out in our written case. But obviously, with the exception of the objective harm test, the other two tests do call for evidence. And we say it's impossible, as a matter of logic, to satisfy those tests unless one does know that the person wants the anonymity and the reasons for asking for anonymity. And if the court isn't able to establish that Article 8 is engaged at all, then it simply doesn't have the jurisdiction to engage in the re-S balancing exercise. It would have the jurisdiction to make a precautionary injunction on an interim basis, but not to make a permanent injunction where it simply has nothing to put on one side of the balance. And that's the problem. And this ties in with the third reason under this heading why we say that, these third-party privacy injunctions can't be made in favour of a party without a party's knowledge and consent. And for that, we rely on the judgment of this court in the case of Cameron. And I don't propose to... in a way, it's the same point that's been made under Article 8. But the point there is that you're bringing someone under the jurisdiction of the court without letting them have a chance to say anything about this. I'm going to make an injunction, and it was no doubt an inadvertent result of the injunction in the Haastrup case, but it hasn't been changed. And I can take your lordships to it if necessary, but it's written in such broad terms that one of the implications of the injunction is that it could prevent the clinicians themselves from posting their own names on social media. in any context whatsoever. And it may be that some have no objection to that and just don't want their names appearing anywhere. But others may well have objection to that and should be given a chance to express those concerns to the court. And that's the principle of fairness, which we say in Cameron does apply. It doesn't raise the same issues. I'm aware that the court had to look very carefully at Cameron in its recent decision in the Wolverhampton case. But this isn't about newcomers, type 1, type 2. This is about people whose identities are very much known and for whose benefit the injunction is ostensibly being made. And in those cases, they simply have to be before the court.
If you have specific suggestions as to how appropriate safeguards might be built into an injunction of the kind that we're talking about at some point, then it'd be useful for us to have those.
I was proposing right at the end of my presentation to deal with a possible way forward, and I think I'll certainly address that point. The Article 6 point, which we started looking at, and I will have to seek authority on, if there is any.
I was going to say, I'm not aware of authority that Article 6 protects open justice at all. That's a sort of fundamental point, if there is any authority on it. I'm inclined to think that open justice might be protected by Article 10 rather than Article 6, but if you have authority, that would be helpful.
Well, the authority I wanted to just briefly take.
I mean, other than the public hearing element, obviously, and the ability to make submissions and so forth, but the reporting of or publication of proceedings, I'm not aware of authority that's covered by Article 6.
So I shall reserve my position with regards to the authorities, if I may, over the lunch adjournment. The authority I did want to take is the Grand Chamber decision in Martigny and France, which is at 3975, is the passage that I wanted to look at. And this, I mean, there's certainly many cases where before Strasbourg where people have complained that they'd been denied a fair hearing for various reasons. And in this case, the passage which I wanted to look at was paragraph 40. The right to a public hearing implies a public hearing before the relevant court. Article 6.1 does not, however, prohibit courts from deciding, in the light of the special features of the case submitted to them, to derogate from this principle in accordance, and this is the words we lay stress on, in accordance with the actual wording of this provision, and the provision is then cited, the press and public may be excluded from all or part of the trial in the interests of morals, public order, or national security in a democratic society. And then this is the important point, where the interests of juveniles or the protection of the private life of the parties so require. And then the general catch-all, which is an important one, which ties in with the inherent jurisdiction's powers in this country as well, or to the extent strictly necessary, in the opinion of the court, in special circumstances where publicity would prejudice the interests of justice. And then it says, holding proceedings either wholly or partly in camera must be strictly required by the circumstances of the case. And so the importance of this provision, we say, of the decision of the Grand Chamber of which looks at the precise wording of Article 6, is that the privacy protection extends to the juvenile and the parties. There's no privacy protection which extends to witnesses or third parties or other people. And
Yeah, but I mean, the concept of public order, which is also listed there, is a very broad one.
Yes.
So if you had people rushing around causing unjustified harassment to witnesses or other people who might be identified in the proceedings, I would have thought that it would be possible to exclude press and public on the public order ground for those. You wouldn't have to bring them within the latter part of this qualification.
But my lords, my submission on that proposition is that it's a high threshold. And when we look at the public order derogations in relation to Article 10, we'll see just how high that is. It's not simply the case that the court can say, oh, well, there's a risk that someone's going to write an offensive article on Twitter, and therefore that satisfied the public order derogation. It will be a high threshold. People have open justice rights, and if they're going to be derogated from, this is the force of the submission.
This, of course, is focused on the question of whether the hearing is in public or in private. It's not focusing on publication of what takes place.
Well, we say it's inevitably the same question about whether the press is able to report on what happens in the hearing is what's being targeted there. I mean, a hearing can be held in private in different ways, and this will be.
Well, for example, during a rape trial, the complainer the public, general public will be excluded, but the press won't be. The press will be present in court when she gives her evidence. She'll give her name, be the first thing she'll be asked. But the press will not report that. I believe they're prohibited from doing so by statute. That's not an infringement of the of the right to a public hearing.
But that's we say that would be manifestly permitted under the interest of justice derogation. There's no doubt about that. We say. I don't want to press this ground any further, but it is a ground we do pursue. And we say that it is relevant, and it ties very much when we look at how the common law treated this issue. When we look in the open justice submissions, because this really does go more to the question of discretion, that the sort of derogation to open justice which prohibits the naming of witnesses is, in this sort of case, very, very exceptional jurisdiction and would require a high threshold. The final ground on jurisdiction is a prescribed by law ground, which covers a bit of territory. What we say is that there's no proper legal basis for interfering with Article 10 rights in these circumstances, because the injunction was not, in the circumstances, prescribed by law for the purposes of Article 10.2, and we're going to get into the question of the positive obligations, which the court is the positive obligations under Article 10.
I thought you'd accepted that.
Under Article 8, I'm sorry.
Sorry, I thought you'd accepted that Section 6 of the Human Rights Act and Section 37(1) are the prescribed by law bit, and which gives jurisdiction.
Yes.
And thereafter the argument is whether or not it was correctly applied, rather than.
Yes, in that case it would go to the adjudicative jurisdiction point. But the point we're making is a prior point, is about whether the court's entitlement to rely on the Section 37 powers is triggered or not, and we say it isn't, for the reasons that I'm going to set out. So it is accepted, and this has always been the case, that the Human Rights Act does confer a power on the courts to engage in the in re-es balancing exercise and to make those injunctions if it's appropriate. But, as we say, this power is only triggered when the court is under an obligation to act. It is not a jurisdiction which exists simply because a person makes a request to the court. And there are three situations, three circumstances in which this obligation to act is triggered. The first is where there is an existing cause of action in domestic law, such that the courts are obliged to adjudicate on the balance between the rights at issue. And if I could take the court to the Campbell case on page 2189, and I'm looking at paragraph 132, where Baroness Hale says the 1998 Act does not create any new cause of action between private persons. But if there is a relevant cause of action applicable, the court, as a public authority, must act compatibly with both parties' convention rights. And this, for example, is what happened, and then where the domestic courts failed to give proper effect to those rights in the von Hanover case, which we'll be looking in a little bit more detail in due course. But that isn't the case here. It's always been accepted by the trusts that there's no freestanding cause of action under which they could properly bring a claim before the courts. The second situation engages the negative obligations under Article 8, and that typically, those would be obligations which could oblige the court, for example, when it's considering whether to publish someone's name in a judgment. And we mentioned the case of Clifford and Millicom. We'll come back to that in due course. The important situation is the third one, and that's where the court, as an emanation of the state, has a positive obligation under Article 8. Now, the state, of course, has plenty of positive obligations under Article 8, and the von Hanover case is an example we'll turn to very shortly. But it has these obligations to provide protection for people's privacy rights, and it does this by appropriate legislation or ensuring there are appropriate remedies for breaches. And in this country's system, it's primarily through the legislator and not the courts that these obligations are discharged. This is a situation absent a particular cause of action.
But I thought it followed from the discussion we had before that you accept that sometimes the court will be the appropriate emanation of the state to fulfil a positive obligation.
Yes. And it's a central issue in this is when will that be? And I think when we look a little bit more at Wolverhampton, we'll see the sort of safeguards that this court felt were necessary when it was exercising an equitable jurisdiction before it did so. But yes, but what we're saying in these circumstances, and it is a matter of significance, that there are a great number of privacy protections in this country, which cover the criminal and civil law, and the courts have recognised common law protections as well. People have a lot of different ways of vindicating privacy in this country, and we're saying that it's in those circumstances it would be exceptional circumstance for the court to find a new obligation where one didn't otherwise exist.
Can I just make sure I'm understanding this? In Campbell, as we see, Lady Hale says that 1998 does not create any new cause of action between private persons. And in that case itself, as she goes on to say, the relevant cause of action was breach of confidence. And in Venables, we would have to look at the case, but I was looking at what we said about it in Wolverhampton, and it looks as though what we say in Wolverhampton is that the claimant applied for the ban on the basis that the information in question was confidential. So it seems to be a breach of confidence action also. Is the argument that there is no cause of action available as between the hospital, or for that matter the doctors, and the parents?
Yes, it's the information which the parents seek to reveal is who treated their child. It's not they're not seeking to reveal people's addresses or personal details. It's simply Dr. X treated my child. I was very happy with Dr. X, or I was very unhappy with Dr. X. They're not allowed to mention that. And it's what we say is that there's no the confidence. I think this was a point that was looked at yesterday, but it's certainly part of our case, that the confidence is one way in that sort of professional relationship. A patient has a reasonable expectation of privacy, that the doctor's not going to reveal medical details about them. But the doctor simply doesn't have any reasonable expectation of privacy, that the patient is not going to mention the fact that they received treatment from them. Perhaps they're going to fill in an online review, which they do, which people do in all sorts of professional contexts. Maybe it will say good things, maybe it won't. But that information is not confidential, and therefore there isn't a reasonable expectation of privacy. But also there's no unlawfulness in what the parent, if it weren't for the injunction, what the parent is proposing to do.
Is there a cause of action against persons unknown for harassment or privacy or?
There may be, and this is one of the points in Wolverhampton, one of the safeguards that this court suggested needed to be fulfilled before a person's unknown injunction was made, was that the precise illegal behaviour had to be clearly defined. And these injunctions say you're not allowed to name the patient, and this isn't unlawful behaviour, and that wouldn't be the appropriate subject matter of such an injunction. If there was an appropriate injunction, it would be you're not allowed to, one could imagine, one's not allowed to publish online abuse or threaten or publish personal details. That would be a sort of injunction which could be made, but not one which says a patient isn't allowed to reveal who treated them. That just simply goes too far.
So really, you say we should distinguish authorities such as Venables, where the newspaper gets hold of information about the new identity given to the person, or cases to do with breaches of confidence in the context of private relationships. Because here, the information the parents want to reveal is doesn't have any confidential character, and they are not taught or other legal wrong by revealing it.
That is the distinction we would make. And
can I just test that in the context of the sort of Broadmoor and Robinson type of claim by the hospital? I'm thinking of paragraph 31, Lord Wolfe's summary of it. The hospital seeking to prevent interference with the conduct of its medical work. It fears that if the principal clinicians are named, this will bring down a firestorm of press and or social media type abuse on those clinicians. Now, although there's no suggestion that in naming the clinicians, the parents are themselves committing the unlawful acts which the hospital is anxious to try and restrain, they would be a conduit through which the identity of the relevant clinicians would reach the bad guys. Now, is there no jurisdiction there to grant an injunction, as it were, stopping off the conduit at source by restraining the parents from disclosing the names?
Well, there is, and we'll come to that when we look at the risk direction and the Strasbourg authorities, which are dealing with the sort of restrictions on Article 10, and this is what's involved here, which are justified under Article 10.2 in order to prevent third parties from acting unlawfully.
Yeah. It might be said to be an analogy with the internet blocking orders.
Yes.
Where you, as a practical way of preventing the wrongful behaviour by third parties, you target the injunction at the people over whom the court can exercise control.
I think that would be the appropriate way if there's a need to act, and we'll also get on to that question, because it's not really clear that the fears of the trust have been realised in other cases where the injunctions have been lifted. But we say it would be appropriate in those circumstances, and the trusts rely on a case called Delphi and Estonia, against Estonia, where, but there it was the internet service provider who's responsible, and that's where the responsibility lay. And if the court felt it was appropriate that things were getting out of hand, then rather than stopping the parents from being able to say what in itself is innocuous and what they should be free to say, it would be appropriate to target the conduits of the incitement and of the unlawful behaviour. The two cases, I'll take them very briefly then, because we've covered this ground, but the case of X and Y in the Netherlands at 4283 is a case which apparently illustrates how a court may have a positive duty to act under Article 8. That case concerned a situation where there was no domestic legal redress provided by the criminal law for sexual crimes committed against a person over the age of 16 who had a serious mental handicap, which meant that they weren't able to report those crimes themselves. The law did not permit those crimes to be prosecuted unless the complaint was made directly by the offended party. And in that case, it's clear, we say, that the failure was the failure of the legislator, not the courts. The obligation was for the state to provide suitable criminal law protections, not for the courts to step in and try and rewrite the law. So there was a breach of Article 8.
But, I mean, in the area where very sort of sensitive judgments are required to be made on particular facts as to whether there should be orders preventing reporting and so on, it's always going to be a partnership between the legislator and the courts, isn't it? Because typically the legislation will be set down in broad terms, giving a discretion to the courts, but not trying to resolve every dispute that will come before a court. And then it's left to the court to use that jurisdiction, apply principles, and come to the particular result in the particular case.
Yes. That would be the situation. But what we say in this, for reasons which maybe we'll develop more fully when we look at the adjudicative jurisdiction exercised by the court, we say that in these circumstances, it was appropriate for the courts to step back and say we're dealing with such sensitive matters, potentially of very broad effect, and which deal with very important matters to which strong Article 10 rights apply, that if there is to be an intervention, that this is something for Parliament to get involved in. It's not appropriate for the courts to develop new remedies or new causes of action.
But sorry, just on that, I mean, Parliament has been involved. It's passed the Human Rights Act. It's made a court a public authority subject to the duties under Section 6 And we know sometimes, query when, but sometimes there will be positive duties on the court as the relevant body which imposes a duty on them under Section 6.
Well, and the way this duty, and again, this is a position we fully endorse, the way this duty is given effect to is through the in res approach. And that's the approach that the courts would apply. But what's being proposed now is, as we'll see when we look at a little bit more detail at comparison between, I think in the open justice submissions, I'll be looking at in res in relation to what's going on in this case, that what's happening is a very big expansion of the, and this we endorse what the Court of Appeal says, a very big expansion of jurisdiction in a way which we say Lord Steyn said was impermissible. That this is a new class of case which the courts don't have power, absent the most compelling circumstances to engage in. And we say this simply is not a case in which the most compelling circumstances threshold is made out, either for the constitutive jurisdiction to exist or for the adjudicative jurisdiction to be properly exercised. It's however one wants to look at it, into Lord Steyn's.
Right. But you're addressing us at this stage, as I understand it, on the prescribed by law requirement.
Yes.
I can well see that before you get a positive obligation on the state, it usually has to be compelling circumstances in a very loose way of talking. But if you meet whatever is the standard for a positive obligation and the court is the relevant body, isn't that it in prescribed by law terms? Because it then has a duty under Section 6 to take action.
So what we're saying is that duty is only triggered if there is an actual duty to act on the court. Now, I appreciate that even on our case, we accept that there will be circumstances where that duty is triggered, and that may be a matter for the court to decide whether the equity is so strong that the court's obliged to step in and act. But one has to pause there a moment. And
I'm so sorry. You say the equity is so strong. Won't the duty to act will arise directly under Section 6? Either you have a duty or you don't under Section 6, I would have thought.
We're saying, on our prescribed by law point, we're saying that there has to be an underlying duty in order to trigger that. And what I think what would be useful to illustrate the point I'm perhaps not very successfully trying to make is to look at the implications of this argument. It's true that the trust is putting forward. Essentially what they're saying is, and I hope I'm not misstating the case in any way, but the court's obligation under Section 6 of the Human Rights Act to make an adjudication is triggered by the fact that the matter has been raised before the court in an existing dispute. But it's an existing dispute which the trust accepted. There was no underlying cause of action which gave them direct access to the court. How they put it, they were saying, well, the inherent jurisdiction is the vehicle. We say we don't think that's an appropriate approach, but there are court proceedings. Someone within the context of court proceedings says, we want injunctions. Some of those injunctions do relate to the court proceedings. So for the purposes of the point I'm making now, I'm not addressing whether witnesses should be named or not, but people who are unconnected with the proceedings, as the trust says. We want an injunction. Where does this duty stop? And every time a party asks the court and says, well, look, there happens to be a dispute. I'm before the court on a trademark dispute, but I also say, and by the way, someone's blocking my drive and I'm not able to get to church on Sunday, therefore you've got a duty to act under Section 6 to give effect to my Article 9 rights, and you've got that duty, you have to engage in the balancing exercise because I've brought the matter properly before the court. Or alternatively, perhaps say, well, this is completely unrelated to the case, and it has somehow to be related to the proceedings. We have perhaps a case of a celebrity who's in a dispute with a newspaper and says they're misusing my private information. I need an injunction now to prevent this newspaper from ever making mention of me again, unless they present to the court beforehand evidence of what they want to say, and the court can engage in a balancing exercise. And the court's obliged to give this injunction because, and it would have grounds for seeing that the newspaper had already breached the person's rights. But the court's obligations under 6.1 are therefore triggered because I've raised this issue before the court. It simply can't be right. However one cuts it, one's creating a cause of action where one wasn't there before. And so what we say is that this obligation on the court under 6.1, it doesn't simply oblige the court to act whenever a litigant raises an issue for which they have no right under law to raise. It only exists if there's an obligation on the court to act at all. And the obligation to act at all exists if the 6.1 obligation exists, if there's a legitimate cause of action so that the court is properly seized of the matter, or, we say, in circumstances where the state itself has placed a party in a particularly invidious position. And this is how we say the Venables or the Mary Bell type cases should be looked at. Because a party is being exposed to public opprobrium, maybe because of even their own faults, but through a public law process, this will be criminal prosecution that the state itself has initiated, then the state now has duties towards that person to act and to give effect to their Article 8 rights, a positive duty. But that's a special circumstance. And it just can't be the case in private law proceedings normally that that duty to act under 6.1 is triggered autonomously or absent a cause of action. And that's really the point on jurisdiction. How the trust then tries to frame the argument, to say, well, look, this is different. It's a horizontal dispute. The rules don't apply. They say there's no interference with, since there's no interference with convention rights by the state, we have no issue of a necessity for the matter to be prescribed by law. And the court simply has to engage in this jurisdiction when it's called upon to do it. Our response to that is, first of all, that it's not so straightforward to classify the underlying cases as horizontal disputes. They may not be private law proceedings, but there are NHS trusts involved, and by extension, their employees are also emanations of the state. And the original injunctions in the Abbasi case prevented the naming of the trust itself. We're now also being told by the medical interveners that the injunctions are necessary to protect the National Health Service. So, but anyway, even if it is a horizontal dispute, the interference at issue, and the one that needs to be prescribed by law, is that which the courts are taking to restrict speech. And it's the courts, by making the injunctions, I think more accurately, even by the case being brought to court, is when the interference of Article 10 starts. But it's that action of the courts which needs to be prescribed by law. And that requires their power under which they act also to be clearly prescribed. And I could take your lordships to the case of RxG in the Ministry of Justice, page 3249. And I want to look at paragraph 35 and 35.1. And it's there, in this case, in RxG, the court surveyed the jurisdiction to make contramundum and anonymity orders under the Venables jurisdiction. And it's a simple point, but given the submissions which are being made by the Trust, it's an important point to make. The court there correctly affirms that the exercise of freedom of speech can only be interfered with by a state body, in this case the court, if each of the Article 10.2 conditions are satisfied, including that it's prescribed by law. And that's that point. Finally, on this prescribed by law point, I wanted to look briefly at Wolverhampton, and I'd ask your lordships to turn to page 4431 and look at paragraph 170, where the court's looking at justifying the constitutional propriety of injunctions by reason of the fact that the local authorities were seeking to prevent commissions of civil wrongs recognised in law. And the court said, we do not accept that the granting of injunctions of this kind is constitutionally improper, insofar as the local authorities are seeking to prevent the commission of civil wrongs, such as trespass. They're entitled to apply to the civil courts for any relief allowed by law. In particular, they're entitled to invoke the equitable jurisdiction of the court so as to obtain an injunction against potential trespassers. For the reasons we have explained, the courts have jurisdiction to make such orders against persons who are not parties to the action, i.e. newcomers, insofar as the local authorities are seeking to prevent breaches of public law, including planning law and the law relating to highways. They're empowered to seek injunctions by statutory provisions, such as those mentioned in paragraph 45 above. And the point being that these were cases which involved convention rights on both sides. But it wasn't simply saying, well, we've got power, we need to give effect to Article 8 rights and property rights of one party against Article 8 rights of the gypsies and travellers. The point is there were legal provisions which entitled the court to exercise the equitable jurisdictions. There were underlying statutes and the issue of trespass wasn't disputed in that case, as I understand. It was a Part 8 claim. What would happen would be a trespass, and there was action available. There were causes of action available, and the court could step in those circumstances to give effect to the wrongs which would be committed. But in this case, there aren't, and we say that it's a requirement of the injunctions in those cases that there is this risk of harm which would otherwise be actionable. We say that by similar extension, this should apply in the contra mundum privacy injunction cases, that there must be actual threat and unlawful conduct. And this is necessary because Article 10.2 requires, in order for a restriction to have effect, for the restriction to be prescribed by law. And it's simply not enough just to say, well, we've got an obligation to act under Section 6.1. It's an obligation to act, but in order to give effect to an underlying right that exists. And in this case, there isn't one. The mere mentioning of a name of a doctor who's treated you or your child is not a wrong recognised in law. And therefore the this equitable jurisdiction isn't engaged. That, my Lord, subject to the Article 6 point, which I hope to just reflect on over the lunch break, concludes the submissions on Part 1 on jurisdiction. And I now propose to turn to Part 2, which is the defence of our way, of the way the Court of Appeal conducted the balancing exercise, in particular of the generic evidence, risk, compelling evidence, and open justice directions, which have come under criticism from my learned friends. Before turning to these, and of very much of relevance to the issue, to the balancing issue, I wanted to address two matters upon which my learned friends place substantial weight. The first is the fact that the parents did not provide, when invited to do so, specific details of precisely what they proposed to say and against whom. And the second, that they did not agree to hold a fact-finding hearing to establish whether that which they wanted to say was true or not. My Lord Stevens rightly observed with regards to the second matter that such an enterprise would have been likely to have been immensely costly for the parents. And this is also has to be borne in mind. It's in a context of a no-cost forum, where even if they'd been vindicated, there would have been no way of recovering those costs. But it's also not clear what purpose such a fact-finding hearing would serve. The parents want to identify that particular clinicians provided treatment to their children. And it is precisely this that the injunctions prohibit. There doesn't seem to be a dispute about that fact, whether or not a doctor treated your child. They don't prohibit allegations against the clinicians, and that's what the fact-finding dispute would have been focused on. But that's not what the injunctions prohibit. The privacy protection sought by the trust is premised on this information, that precisely that a particular clinician treated the child being true, and that there's privacy but at the same time, privacy and reputational protection under Article 8 and under, for example, the misuse of private information tort protects precisely information because it's true. So what's this fact-finding hearing going to establish? That there's true information? That's not what's at issue. If it's false, then injunctions wouldn't be available under the rule in Bonnard and Perryman. And so that doesn't seem to help them. And if the information is true, then they need to rely on the misuse of private information torts, which they've chosen not to rely upon. But there's a further fundamental reason why the trust proposal simply cannot be correct. And this is because it would inevitably import into UK law a prior restraint scheme which risks being operated any time there's any dispute about what someone wishes to say. And there are plenty of authorities. I cite a recent one of Mr. Justice Chamberlain in Her Majesty's Attorney General in the BBC, which can be found at page 2368.
Sorry, can you give me that page again?
2368.
Thank you.
And at paragraph 44, the Justice Chamberlain says, in a democracy which guarantees the right to freedom of expression, the default position is that people can say whatever they wish. They do not require the permission of the court before doing so. Anyone who wants to obtain relief which interferes with the right to freedom of expression must persuade the court to grant that relief. If the court does so, it undertakes a positive act. If relief is sought on the basis that Section 6 of the Human Rights Act requires it, this must be done because of a positive obligation imposed by the ECHR. This is how Dame Elizabeth Butler-Sloss understood the position in the First Venables case. And I gave the example before, won't repeat it, but of the celebrity who's obtained a permanent injunction against the newspaper and is now demanding and insisting that the newspaper provides copy, advance copy, before publishing anything about the celebrity anymore. And the court is going to have to adjudicate every time a story is proposed to be published. This simply cannot be right, but that's where the trust submissions must lead. My lords, that takes me then to the generic evidence direction. And any restriction, we start by looking again at Article 10. Any restriction has to be justified under Article 10.2, and the appellants claim that the generic evidence can, contrary to the Court of Appeal's findings, properly justify such a restriction. And we see three possible Article 10.2 justifications have been invoked in the present case. The first is the prevention of disorder or crime. The second is the protection of health or morals. And the third is the protection of the reputation or rights of others. And there was some criticism yesterday of how the Court of Appeal dealt with these issues, and there was a suggestion that perhaps a straw man argument had been raised. But we say that isn't the case, and that's not a fair characterization of the process that the Court of Appeal adopted. They were responding to the judgment of the President, who raised the public policy aspects relating to, this is on page 113 of his judgment. I don't have the page reference with me, perhaps. I can just quickly find it.
Sorry, do you mean paragraph 113?
Paragraph, I'm awfully sorry, paragraph 113.
If that's the paragraph, I think it's page 346.
346. I'm very grateful. So paragraph 112, we see the justification for interfering with the parents' Article 10 and Article 8 rights to free speech is twofold. Firstly, that there are countervailing Article 8 rights attaching to the individuals and the two staff groups. Staff's Article 8 rights include but go beyond the basic right to private life. In this case, on the unchallenged evidence, it includes the right not to be made vulnerable to personal attacks in social media or to physical attack as a consequence. And that goes both to the Article 8 rights, but also potentially to the disorder and crime rights, the prevention of disorder or crime derogations, which the Court of Appeal then had a look at. It includes the right to go about their job without being adversely impacted so that their mental health or well-being is affected. It includes the right not to be exposed to those other than the parents, identifying their address, phone number, email, and other information, which may then be published on social media. So none of this, obviously, is what the parents are seeking to do. But the worry is that other people might do that. The second manner in which interference with the parents' rights are justified in the case relates to aspects of public policy, and by reference to the text of Article 10.2 concerning the interests of public safety and protection of health. For the reasons that I've given, accepting Mr. Miller's submissions, reference to the matters set out in Article 10.2 are not required in a horizontal dispute such as the present, where, however, matters within Article 10.2 are relevant, as I find they are here. The court must be entitled to rely upon them rather than, as in a vertical case, having to find them established as a requirement. So this goes to the submission that we don't accept, that these disputes don't require Article 10.2 justifications. We say they do. So the President's saying, I don't need to establish that the legitimate aims are made out because it's a horizontal dispute. And there's no requirement in horizontal disputes to do that. We say this is a proposition for which no authority has been put forward at any stage in these proceedings. It's been obviously a submission which has followed us up to to this court. But it's wrong. The RxG case is authority for saying that it is wrong, because when the court is imposing the injunctions, the articles tend to, legitimate aim requirements have to be made out. So the President has said, look, I don't have to find these established. I can just simply rely upon them. And that's the problem with the President's approach to the balance. But no legitimate aims were made out. There was reliance on public policy, but there was no ticking the legitimate aims box, because in order to do that, one would have had to have made out that there was the risks of harm across the relevant thresholds, and we'll have a look at what the Strasbourg authorities have to say about that. And that's the problem. So when the Court of Appeal started looking at that, and it looked first at the public safety and the protection of health, it mentions in paragraph 125 of its judgment that, again, and my apologies, I don't have the reference at hand, but we'll get it.
It's just paragraph 125.
Yes.
310.
I'm very grateful. So this was the paragraph which came under criticism yesterday, and there was a suggestion that the Court of Appeal had constructed a straw man. But the President referred to public safety and protection of health in the context of this aspect of the balancing exercise he was invited to undertake. No Strasbourg authority was cited by Mr. Miller to the President, or indeed to us, to support the proposition that in convention terms a right to freedom of expression could be curtailed because of the sort of systemic concerns identified in the evidence and submissions before the President and us. So it's not that the Court of Appeal is, when it then goes on to look at the public safety side of it, it's not that it's forgotten that there's a right to health derogation, as it were, to Article 10.2. They're dealing at that point with the public safety policies which the President had identified as justifying the derogations, and they're saying, look, these are not made out. This sort of concern is not one which would fall, which there's any authority in Strasbourg which would allow it to be justified on grounds of national security, territorial integrity, or the prevention of disorder and crime. And then when they look at the health, it's not denying that there's a legitimate, potentially a legitimate aim, but again, you recall the President didn't find it established. He then says we're not aware of any Strasbourg case which has come close to allowing concerns about morale, recruitment, or general well-being of health of staff to provide a justification for curtailing the right to free expression. So if there is such a justification, and this not in the proportionality exercise, but this on the legitimate aim point, one would have expected an authority to have been adduced, saying protecting the morale of hospital staff is a legitimate ground for derogation of free speech. And that's what was missing. And the Court of Appeal was aware of that. It wasn't skirting over the issue. There are not many cases which deal...
Sorry, just on that.
Yes.
I mean, I would have thought if you cannot recruit into a relevant speciality, that potentially that would harm the protection of health. I mean, I can see that there may be arguments that, in terms of proportionality, once you look at it, that there's an insufficient link and so on. But just in terms of whether there is a legitimate aim called in question by the points raised here, why isn't the legitimate aim protection of health?
We have to look at the Strasbourg case law to establish what that means. It's not just because...
forgive me, but if you're not treated for something where you need treatment, your health has suffered, but it doesn't seem a very complicated idea.
Well, I mean, one approach is to say, well, anything which relates to health potentially falls within the health exemption. Another approach would be to say, let's see how Strasbourg's actually interpreted the what that means, what sort of legitimate aims can be established under that particular heading, and that's what wasn't evidenced. That's what wasn't made out, and it's certainly the president himself didn't think he even had to establish a legitimate aim, and that's the problem in the balance that he undertook, we say.
Yes, thank you.
The cases, there are two cases in the... My lords, I wonder whether...
Yes, if you're about to turn to a new authority, this might be a convenient moment. Very well. We'll adjourn just now and resume at 2 o'clock.